So real estate professionals should not give legal advice. I always start with that because I think there are certain triggers a real estate professional can look at. Or look for. They can see certain things in their table of discussion, initial meeting, that can give you the thought that I'm not sure if I want to talk to this client right away without making sure they themselves know what they're talking about. Because you're relying on them. It's not your job to go do legal research on their position on the sale, nor is it your job to give the advice. For example, I actually have one real estate agent who, and this is not bankruptcy related, this is more related to just real estate professionals not giving legal advice. He ended up meeting a client, and she must be in her 80s, and she's the sweetest lady, no family, nothing. And she wants him to list her property, and that property is worth about $4 million. He's excited. He's been helping her. He's taking her shopping. He's doing above and beyond what the real estate agent would do. But what happens if he sells that house? He gets a commission, and she gives him a gift. She puts him as a trustee. Is that okay? No, because first of all, the beneficiaries that she never told him about could sue him. He could be sued for elder abuse. He could be sued for fraud. He could be sued for a bunch of things. So what I advised him is to say, look, maybe your client should go meet with an estate attorney to make sure that estate attorney knows that she has the capacity to make these decisions. Yes, it's overkill. Yes, your commission's at risk. You could lose a transaction, but losing a transaction is a lot better than getting sued by me, because it's going to cost you twice as much, or 3 times or 4 times as much. So these are things. If your client is way too happy, alone, has millions of dollars, and doesn't have any family, I'd think about that. I'd make sure that she has some kind of estate planning in place. I would say, look, you should go meet with an estate planning attorney. Do not tell him who to go to. Do not take him to the estate planning attorney. Just say, go meet with somebody. Look online. Here are like 4 or 5 names. Go ahead. You can give them referrals. I would give them more than 1 referral. I would give 3 referrals. I wouldn't drive them there. I wouldn't help them. I'd say, here's a name, go figure it out. Because you want to create that separation as much as possible. Now, that's estate planning. In bankruptcy, I think it's a little different, because in bankruptcy, it's more of the real estate professional refers the client to an attorney, and the discussion point is really financials. Like, hey, man, this is my client. He's going to lose his house. Can you just talk to him and see what's available? And then we talk, and then we get a foreclosure. The real estate agent is intricately involved because we have to sell that house. So, and we'll go over that. So the point is, that if it's an estate issue, to look for that. If you're sitting with a client and you find out there's a foreclosure, you find out there's some kind of risk financially, you're going to need to let them know that your sale is going to be contingent on a bankruptcy court order. So if they file bankruptcy before the sale, if you want to sell it after the bankruptcy, the court has to approve it. It can't just happen. And you need a team of people. You need the attorney, you need escrow, you need possibly a CPA. You need these people to be around and bless the sale, or escrow's not going to close, because escrow's like, up there. They don't like you, or they don't like the document, they're not going to close it. They might not like you, they just don't like the document. What happens? So how can you help? I think a real estate professional can help in many ways. I think when it comes up to the fact where you're in that meeting and you hear the key words such as default, bankruptcy, power of attorney, trust, will, death, those words come up, you would suggest and say, I think you should seek counsel before we make this, sign this listing agreement or whatever. And the purpose of that is indirectly to make sure you don't lose the deal. It's not directly saying, go do this so I can list your property. It's like, go figure your life out legally, and then we can go forward in a clear path. Does that make sense? Questions on that? No? Okay. Tell me. Well, it depends what they mean by done. I mean, have they made their payments, their planned payments, and they got a discharge, or has it been dismissed? It all varies. I mean, but most likely they mean it's done, meaning it's finished, means it's discharged. But a lot of clients don't know the difference. They might mean it's done, meaning I never received a discharge and my debt still exists. I just closed it. Or bankruptcy's been filed and I stopped making my bankruptcy payments. The bankruptcy's floating out somewhere there, and it's still active in the eyes of the court, but it's not active in this person's. So, that type of stuff needs to be clarified. Well, you could either have a bankruptcy that's dismissed, meaning they never received the benefit of the bankruptcy, meaning all that debt still exists, or you got a discharge, and the discharge means all the debt goes away. Yes, sir.
Dismissed, they can sell.
If the bankruptcy is dismissed, they can sell. Various reasons. If it's dismissed, meaning it's closed, means it doesn't exist, you can do whatever you need to. But dismissed also could mean that they never got the benefit of the BK. It just went away.
Yeah.
Yeah, exactly. Well, I mean, the dismissal means it's not active. That's the key. Correct. That's correct.
So if the bankruptcy is filed and the home needs to be sold, and then the owner says that everything is fine, whatever he means, we don't understand that. Do we need to get connected with the attorney?
I would suggest if there is a bankruptcy that's been filed, unless they filed it themselves, if they have an attorney, yeah, ask your client to give you authorization to talk to the attorney, just to understand where in the bankruptcy process it is. It depends on the attorney. Sometimes they have written, sometimes it's just an email. Just say you'd like to know where in the process it is, because, and you could ask the attorney or ask your client to ask the attorney, will this bankruptcy require a court order? Or when I make a listing agreement, should I say subject to bankruptcy court approval on the MLS? Because, you know, subject to bankruptcy court approval, subject to probate, subject to trust, different things that are gonna come in the way of closing that deal. Yes, sir.
Just to clarify, is that they didn't get the benefit from the bankruptcy?
Yeah, but dismissal means it goes to everything it was before the bankruptcy was filed.
And then say when that is closed.
Well, when the debt's gone away, I mean, you don't owe it anymore, it's called a discharge. Yeah. Questions? Okay. Tell me.
They file chapter 13, and still go, is that
I'll get to that when I talk about different chapters. Okay. So I try to go to some basics because I can't assume everybody knows how to deal with an attorney. Excuse me. So, you know, you want to, if you're going to do bankruptcy, I would suggest that you try to get an attorney or refer an attorney that's local. Sometimes what happens is people look for attorneys anywhere because they think they're an attorney, they can do anything anywhere. Not the case. Every bankruptcy court has local rules that apply to that particular judge or that area. So it's good to find an attorney familiar with the Northern District. We're in the Northern District Bankruptcy Court. Yeah. Oh, it's he'll come back, I'm sure. It doesn't work.
It's just a connection issue for some reason.
Oh, okay. Thank you. Yes, sir.
When you say the DK was discharged, you might be already in a payment schedule that was approved by the court. Whoever is the lender involved,
Right.
that means it's discharged, but it doesn't pay off from the debt. You without continuing your payment.
Yeah, but you get your discharge at the end of the payments. At the end of the plan. That's when you get your discharge. So I'll just use the oh, that's fine. I'll just use the thing here when I come to cases. But anyway, so location, you want to get somebody who practices in this area, in this location. Northern District covers San Jose, Oakland, and San Francisco. So you want to try and find somebody that knows those local rules and those judges, just for purposes of getting stuff done and not delaying because you don't know how it works. That's what I would suggest. There's two different types, well, three bankruptcy attorneys or three practice areas within bankruptcy that you're going to find. You're going to find consumer bankruptcy, commercial bankruptcy, or bankruptcy litigation. Most and the majority of bankruptcy attorneys are going to be consumer attorneys. They represent individuals and small businesses. When I say small businesses, I mean businesses that are not incorporated, solos. So that they just do that. They do chapter 7s and chapter 13s. They consumer bankruptcy. They may do chapter 11s, which are for high earning, high debt individuals. And those are consumer bankruptcies, consumer bankruptcy attorneys. Commercial bankruptcy attorneys will do chapter 7 and chapter 11 for companies, corporations, LLCs, things like that. And there are, you know, limited attorneys that do that. Then you have attorneys who litigate in bankruptcy court For example, if someone commits fraud, you can file a lawsuit in bankruptcy court to prevent the discharge of that particular debt. So if, let's say, for example, I took a loan from you of $100,000 and my documents were all lies, then when I file bankruptcy, oh, thanks. Then at the end of the bankruptcy, that debt is not going to be discharged because you committed fraud to give it to me in the first place. So that is something a bankruptcy litigator would do. My office does all three of the stuff there, so just kind of goes hand in hand. Let's see.
Yeah, that didn't work out. The way that I thought it-
Is it not working?
Yeah, it's not working properly.
That's okay. You guys, if you need my name, you can ask me. I'll draw pictures. Yeah, just, I don't know. That's okay. We'll go old school.
Better anyways.
Yeah. That's all right. Just, I'll just take this, don't worry. Give me a second, please. I will get this set up. Okay, so you got location, you understand practice areas, commercial versus consumer bankruptcy. It's kind of like a residential realtor doing a commercial transaction. There's always a problem. There's always a mess up. Someone gets sued. You know, that's what happens in law. You want an attorney who can handle either all the areas or just focuses on one. The volume is going to be the consumer bankruptcy attorneys. There's a lot of them around. But when it comes to commercial and litigation, there's limited. And at the same time, I mean, not to kind of toot my own horn, but it's good to have someone, if you have a more complicated bankruptcy where, let's say, your client is an investor, or for example, he owns property as part of a development, and there could be litigation, or it's owned by an entity, that might involve an attorney that knows commercial as well, because you can't file a consumer bankruptcy for a company. So those areas do cross, especially now, because of the fact you have people that have a corporation file bankruptcy, but they have a personal guarantee. So those things come up quite a bit. And Ponzi schemes, which are always fun. So, yeah. So let's see. Okay. Some things to know to help your client before the first meeting with the bankruptcy attorney. Have them know their assets and liabilities. They should know what they own. They should know who they owe money to. What are their earnings? What do they make as a salary? Or if they're a business, do they have a P&L or some kind of understanding of what their income has been for the past 6 months and the past 2 years? As for real estate professionals, if a real estate professional files a bankruptcy, that potential escrow, which hasn't closed yet, that's an asset. So if you file bankruptcy and you list a closing of this address and your commission is about 30 grand, the bankruptcy could stay open until that closes because that is an asset of the bankruptcy. So, and we'll go into detail on that in a second. Okay. It's a future asset. It's an expected interest, kind of like an inheritance. Yeah. So, okay. All right, let's try this. My handwriting sucks, so I'm sorry. So when we go to consumer bankruptcy, we have two bankruptcies. We have Chapter 7 and we have Chapter 13. All right. So Chapter 7 is a liquidation. A Chapter 13 is a wage earner bankruptcy. The difference is in a 13, you need income or your case gets, what am I, dismissal person right there, dismissed. Okay. Now in bankruptcy law, well, the procedure is the client comes to my office, we sit down during the intake, and he tells me what the situation is and his assets and liabilities. Based on that analysis, I decide whether a Chapter 7 is better for him or a Chapter 13 is better for him. Okay. Then we sign up the case. In a Chapter 7, there's someone called, well, in both chapters, there's someone called a trustee. This trustee's job is to find money. The Chapter 7 trustee finds money for the benefit of the creditors. The Chapter 13 trustee finds money, but also makes sure the payment plan you propose is feasible. That means if you're going to pay some creditors back, can you afford that? Can you afford the monthly payments to the creditors? Okay, that's the Chapter 13's trustee. Does that make sense? So that's, yeah, they all have a fiduciary duty to the creditors. But in simple language, they just try to find money. If they find money, they get paid. They're on commission, well, percentage. And then 13, they manage the case to make sure you're going to make your monthly payments. Tell me.
They can find.
Because a lot of people can't do that. I mean, it, well, no, big, well, the thing is this, right? I mean, it's a hard decision. When a client comes to me and they say, I owe 50,000 in debt, I'm like, do you really want to file bankruptcy for 50,000 in debt and kill your credit for like 8 years or whatever? Or can you go do something? I don't know, start making phone calls, start making settlements. Some people just cannot do that. It just really, that's not even the legal aspect. That's more of an individual. Do they have the ability, time, or concept to call a creditor, Amex or Visa, and say, look, I don't got the money. Can we make a deal? You can call anybody yourself. You can call anybody. They might not talk to you, but they can call anybody. But I mean, they'll talk to you. There'll be a department. They'll talk to you. But I mean, what is the value of bankruptcy? It's a time, it's a breathing spell for you, but it kills you. It kills your credit. I mean, especially for someone who's starting out their life or career and they're trying to build a business or something, they are screwed. I mean, that's not a legal term, but it's true. You're screwed, right? But there's business people who come back up and they just use it for business. That's fine. There's different techniques to it. But if it's an amount of money and an individual who has the ability to negotiate, I would say take a stab at it first. If it doesn't work, then we'll consider bankruptcy. But don't pay me. Use your money to do something else. So yes, you're right. You could do that. It's just a lot of people can't, or are scared, or don't want to deal with it. I mean, for being honest for a second, a lot of people in bankruptcy are administratively dysfunctional, right? They haven't taken care of their books and records to a level to understand why they owe more than they do. That's the bankruptcies. There are, of course, people who are really suffering in bankruptcy because of medical bills or other issues out of their control. But most bankruptcies are administrative dysfunctionality. And that is where an issue comes up. It's sad. There's a lot of sadness in the world with bankruptcy because of the fact that, people get hurt physically, mentally, things that affect the family. Those are, I see as happening. But the administrative aspect, I mean, did you really have to go buy that Mercedes? I mean, or Tesla? I guess if you can afford it, you can. But then if you buy it and then you can't afford it, you got a problem, So it really comes down to people having that ability. And if they don't have the ability to make the call and negotiate with the creditor, get the attorney involved, So anyway, so chapter 7 of liquidation, chapter 13 is a wage earner's bankruptcy. So in bankruptcy, there's a certain thing called exemptions. Okay, exemptions mean that the individual who files bankruptcy can keep that amount of money or that valued asset. Okay, so I don't want to go into the numbers because it's on my spreadsheet, but I'm not going to write them all down. But let's say, for example, an exemption is $31,950. Okay, that is an exemption amount. Just keep that number in mind. So for the simplest fact pattern, okay, the individual has $50,000 value in a piece of land, okay, and he has $100,000 in credit card debt. Does everybody know the difference between unsecured and secured debt? Okay. Well, unsecured is like a credit card. It's not connected to an asset. Secured means it's connected to an asset, and they can take that asset to pay for the debt. So unsecured debt credit card, $50,000 land. So they file chapter 7, and the trustee says, hey, you know what? The $50,000 value of land exceeds the exemption amount. Therefore, you owe us the difference between 50,000 and 31,950. And I'm not a math person, it's written down. 1850, 18,050. So that's the difference. So the trustee is going to say, hey, you either pay us the 18,050 number to keep your land, or we sell the land and we basically pay the money to the creditors and we'll pay you back whatever amount your exemption is. Okay. So the trustee's job is to get the money into the estate.
They front the 18,050.
Yeah.
The land. Otherwise, the land gets sold. but they still get the 31,000.
They get their exemption amount.
They get 18,050 towards that one unsecured debt.
Right, right. But it won't be that much because what's gonna happen is the sneaky old trustee is gonna bill like crazy and maybe like half of that will go to the unsecured creditors. Okay,
So I got some.
they got them something. Yeah. No, it varies in state laws and different, it can go higher because that's not the only exemption. This is called a wild card exemption. This is like you can do whatever you want with it, but there are exemptions for cars, exemptions for jewelry. There's also your homestead exemption. If you take that, this goes down. So there's various exemptions that come up. But in the simplest sense of it, if you go to a 7 and you have assets beyond the exempt amount, you either pay for it or they sell it. Now, let's say you say, man, I really want to keep that piece of land. Someday it's gonna be worth 5 million. Yeah, good luck. But someday it's gonna be worth 5 million. So then the option is you say, okay, well, how about this? I won't do a 7, I'll do a chapter 13 instead. Okay. And in the chapter 13, what you could do is you could still take that exemption, but you would pay the 18,050 in monthly payments over 3 or 5 years. So the 13 gives you that option. Does that make sense?
But that unsecured loan doesn't go away. 13, you have to pay back the check, an unsecured loan.
So here it goes away 100%. Over there, you would pay back something. Maybe like 1%, 2%, 3%, or 100%, depending on what your asset value is. Now, in this case, this 1850 would be distributed to them and to the trustee and to the attorney's fees over 5 years. So there'll be a bucket of fees owed, which are the 1850 to unsecured creditors, and then the trustee takes some of it, and then the attorney's fees can be put in the plan. So basically, it's a pool of money that's distributed between everybody in the chapter 13. Okay?
So in most cases, you can deplete the plan.
Yeah, if you do a 13. But again, which we'll go into later, the problems with the 13 is you got to make your monthly payment. If you default on that, you go back to a 7 and they sell. What's up?
If they have a loan on that land, are you determining the value, what they owe, loans versus equity? What if it's, what it means to accept that?
Then it won't be worth 50,000, it'll be worth a lot
What
less.
it means to accept
Absolutely. This is just 100% owned property. I'm not, you get into liens and stuff, it's not gonna be worth 50. Yes.
And when can you keep it and when is the selling of the land?
So in the chapter 7, the trustee is gonna say, you wanna keep it, you pay that, or I'm gonna sell it. In chapter 13, you are keeping it, that's where you're making monthly payments. Only a choice. What if he says, the trustee says, pay the 1850 or we're gonna sell it? If he can't pay the 1850, then it's gone. Yeah,
Can anybody pay the 1850 for him?
I would prefer. I would suggest you get a loan or ask a friend or phone a friend and start dialing for dollars and you make it happen.
7 to 13, right?
Yeah.
Where does 11 come in?
Well,
Because I heard that 11 being used for real estate too.
well, no, chapter 11, yes, is for companies, but it's also for individuals. So chapter 13 and 11 for an individual is just a super 13. Because if you exceed the, I don't have it, if you exceed the amount of debt, which is like a couple of $1 million, then you can't do a 13, you have to go to a chapter 11. The chapter 11 is a financial nightmare because what happens is you do everything to put your client in a 13. Because in the 13, it's flat fee. There's no monthly operating reports. It's simple. If you do a 13, if you do a chapter, and after you confirm a payment plan in chapter 13, that's it. You don't do anything else. You just make your payments. But if you do a chapter 11, the retainers could be 15 to 20,000 up front. You're paying hourly, and also every month you have to file a report in the court showing all the assets and liabilities and all the payments that have been happening every month. So it's a lot of administrative work for any individual. So who does it work for? Let's say you're an owner of numerous rental properties. Let's say you're someone who's has a company, but you're the individual with all the personal guarantees, and you got to start paying things to keep the company going. Or solo, like I have, some clients, some individuals don't understand the benefit of incorporating or putting a company in an LLC, so everything is in their name. So you have guys with, I mean, you'd be surprised, but there's individuals with restaurants that have been conducting business for 30, 40 years, but they're not incorporated. It's in their personal name. So if they got 2, 3 restaurants, they're going into an 11. And the nightmare of just the money coming in and out of restaurants every month is challenging. So to answer your question, yes, and the real estate people do it because of the fact that the property value and property debt's so high, and that they own numerous properties in their name. That's when they do 11.
Because the reason why I asked, I heard a case that the consumer has no debt except one of the properties. They couldn't modify it,
Mhm.
so they ended up doing a chapter 11, and finally they resorted to chapter 7.
Right, it's the same thing. They must have had a lot of debt on the property, which was higher than maybe a couple of $1 million. So let's say they have no credit card debt at all, and only the debt on the property. So they have to file Chapter 11 because the debt was so high. They must have filed the Chapter 11 because the modification didn't go through. They filed the Chapter 11 to stop the sale. They try to put a payment plan together or do a modification in bankruptcy. They weren't successful. Then the creditor will say, wait, hey man, this is not working out. You got no plan here. They push it into a Chapter 7, and then the trustee sells. Or the lender sells it, gets relief from staying.
So how long they stay in chapter 13? And then if it's there, then why is there still the sale date for the property?
So in a Chapter 13 is 3 or 5 years is a payment plan, the payment plan. The goal of a 13 is to put a payment plan together. That takes a couple of months. So you tell the trustee, look, this is my job. This is how much I'm going to pay every month. And you go back and forth, and the trustee says, okay, I think you can make these payments. They'll stamp the plan. Then that plan payment goes for 3 or 5 years.
Let's say in a month.
Because sometimes what happens is when a bankruptcy is filed, there's something called an automatic stay that comes into place. That stay stops all collection activity against the debtor. Okay. The problem is, well, the technique I think personally is the lender or the foreclosing company can keep continuing the sale out. Like you'll get a notice every month for a couple of months while there's a bankruptcy, but they can't sell. It's just they're rescheduling the bankruptcy sale date. But they can't sell. They can't sell because it's a violation of the stay. However, sometimes what happens is, and now you're getting into like, you know, tell me.
Big white tracks.
I'll tell you 1 second. I'm hearing something. So now this is kind of what happens when you get involved in like the screwy strategies of bankruptcy. You have bankruptcy number 1, which stops the foreclosure. Okay. Let's say the Chapter 13. Within 14 days, that person who filed the emergency bankruptcy has to file their assets and liability, a disclosure of all their assets and liabilities under penalty of perjury. If they don't file it in 14 days, the case is automatically dismissed. Okay. Sometimes people don't want to disclose it, so they let it get dismissed, and it just goes past that first foreclosure sale. Following me? So then what happens is they file a second bankruptcy after dismissal. The second bankruptcy only gives them 30-day protection.
That's in chapter 13.
13 only, yeah. 30-day protection, unless the court agrees to increase it. 30-day protection, meaning the stay is only valid for 30 days. So then they could do that again to stop the second bankruptcy. But then the third bankruptcy gives them no protection, so there's no value to it for them. So in your question, if these guys keep continuing the sale for 30 days, what could happen is one of these cases could get dismissed the day before, and then their sale could happen because the stay is gone. So I've seen that happen.
So even if they did push forward the sale during the first bankruptcy.
Yeah.
And then after the second one, even if they give them the 30-day protection, day 31, 32, they can cut with those.
If maybe that was already calendared, right? So that's what they could do. So let's say the first foreclosure is on the 1st, and then the second foreclosure is on the 15th. Let's say the first they foreclose 14 days later, it gets dismissed. The 15th they sell.
Second, bankruptcy, they have 30-day protection. How many days is Did they have still 14 days to turn in their assets and liabilities? Does that still exist?
Yeah, it's always, and all. You can extend it, but you gotta have a reason.
They get approved, obviously, they stay protected.
Correct, correct. Yeah.
They gotta get approved before.
Absolutely, absolutely. In this strategy, well, you might not have the time in this strategy to sell. It depends, right? Because let's say, for example, if you have a foreclosure coming up, the whole benefit of filing the bankruptcy is to stop the sale and then give you time to list the property, get top dollar, and then pay off creditors or do whatever you need to do.
Well, if it's listed, doesn't the attorney and the courts take that into consideration?
For what? You mean in the bank?
Resolution.
They do in the bankruptcy, but that should be happening, right? I mean, they should be already listed, should be ready to go. S-
Conversation that you're in an equity position to solve your problem. You need to list your house right now. I understand you're doing this strategy,
Mhm.
but however, the strategy of listing and selling on the market, especially concerning your particular home,
Mhm.
would probably be a higher and better solution.
Right, but the thing is, when you list it and sell, it's gonna depend. If you have a foreclosure date coming up, they're not gonna close before the sale. The bank doesn't even cooperate half the time. So you need that cooperation or you need that time to sell the property. If you gotta, yeah, so, but listing it, yes.
Creditors would understand that, is that homeowner, I got it on the market.
But if you're in a bankruptcy, yeah, absolutely. And you should definitely do that. That should be definitely, yeah, you're protected. Right. But the problem is if there wasn't a bankruptcy and you call the lender and say, hey, the house is listed, they don't care. They don't care at that point. No, exactly. Yeah, yeah.
But if you're in the middle of transaction in your own chapter, not chapter.
13.
No position, so, right, when you're not protected.
Hmm.
So what's gonna happen?
You got nothing to stop a foreclosure. Foreclosure could happen anytime.
Of
Even-
course, but if you already found a buyer in the process of transaction of closing,
I don't think you'll be able to close because the lender won't be communicating with you that well.
only on stage two.
No, I'm saying without a bankruptcy. With the bankruptcy, so long as the bankruptcy stay is active, that's preventing the foreclosure. So that'll give you the time to work with the lender and escrow to close the deal.
So if it's already foreclosure,
If it's already scheduled for foreclosure, you should file bankruptcy before that to stop the foreclosure.
So when is the bankruptcy one?
So these are just three different bankruptcies the same person filed because they play games, right? It's a game system, right? Sometimes they don't want to tell the court what they own or what they have. So they file a bankruptcy, just a skeletal to stop the sale. And then they think maybe they can come up with a buyer, maybe they can't. Maybe they're just trying to live rent free or mortgage free. There's various reasons. I mean, we have people file bankruptcies 5 to 6 times and lived without paying a mortgage for 5 years. I mean, that happens too. Like it's less than a mortgage payment. It's less than a mortgage payment. I mean, bankruptcy is going to cost you 3 to 10, but how much is a mortgage these days? How much is rent these days? I mean, there's so many ways that people have used bankruptcy, but I mean, this is more complex and complicated. But to answer your question, you would file the bankruptcy before the foreclosure to stop the sale. Yes, sir.
If somebody was in chapter 13, somehow moved over to chapter 7, got dismissed, is there still a possibility of them refiling for chapter 13 to try to stop the foreclosure?
They've had people, well, dismissal is different. It has a different rules, but if you have a discharge in a 7, you can file 13 to catch up on payments and sell the property. So you don't get a discharge again, but you can use it as a payment plan.
No, they were in chapter 7. I mean, they were in chapter 13.
Okay.
Moved it to chapter 7,
Okay,
and they got dismissed.
okay.
They didn't make any payments. They just didn't dismiss. Foreclosures come in a month. Can they still file for chapter 13? I guess they would be playing that game for them.
They'd file again. We could probably file again. It just depends on the exact time frame. Every rule here has these exceptions, right? But this is kind of a general understanding. But yeah, I think they could be fine filing. They never got a discharge. It's a dismissal and it's a second bankruptcy. It was the first one that got converted. It wasn't a new bankruptcy.
Right.
Yeah. Holy crap, it's 10:46. I didn't use anything on my outline, guys. So I'm just going to give you the two most important things here to know. Number one, don't give legal advice. Number two, the benefit of a 13. So here's the thing. The benefit of the Chapter 13 for real estate. The Chapter 13 is the only bankruptcy you could individually voluntarily dismiss yourself. A Chapter 7, you're going to need the trustee. Chapter 11, you'll need court approval. Most people won't even object to you dismissing a 13. It could happen. I've never seen it. So why is that a benefit? You have a foreclosure coming. You tell your client, file the bankruptcy, stop the sale. Okay, the foreclosure stopped. You spend the time cleaning up the property, getting it listed, getting it ready for sale. You tell the court, here's the listing agreement. Here's what it's going to sell for. Everybody knows what's going on. Then the property sells. Property sells for top dollar. You don't have to pay foreclosure companies. You don't lose any money. It gets sold for top dollar. You get your commission. Then what happens is, in most cases, if there's other debt, you can pay off the other debt, then just dismiss the case. So the bankruptcy is actually dismissed, not discharged. That could happen in 6 months. That could happen in 4 months. So you have that time to use that tool to stop this foreclosure. That is the benefit of the 13 for real estate. Go ahead. Oh. Okay, number one. Number two is personal guarantees. So when someone goes and gets a loan as a business, as a corporation, as an entity, what happens is this entity is going to require a personal guarantee in most cases from the individual. Now, let's say there's a foreclosure and title's in the entity. The entity files the bankruptcy, okay? And let's say it's a 7 and the property's gone and everything's done. Then the entity goes down. Just because the entity filed bankruptcy and got rid of the debt, that doesn't apply to the individual. If there's a personal guarantee, that individual still owes that money. People don't know that. So it's really important, not for your client, but for you as business people to know that personal guarantee does not go away with the bankruptcy of the entity. All right? Let's see. Ready, set, go. Okay, go ahead. All right.
So the, like, for example, folks, take from, sale of that debt for bankruptcy.
Right. So what happens is an LLC owns title to the property. Okay. But in order for the LLC to get the loan to buy the property, the individual had to personally guarantee the debt. So now let's say the LLC can't make the payments anymore and the property gets foreclosed on. Well, property's getting foreclosed, so LLC files a Chapter 11, is unable to sell the property, so it converts to a Chapter 7. So property's gone. LLC doesn't have anything, can't pay the debt. But since there's a personal guarantee, the individual owns the debt. And eventually what happens is the individual files a bankruptcy also. So that's kind of things you see happen a lot these days with these developer people. Number one. Number two. I like how I just like shoot out just points to know. Yes. No. The LLC itself files a 7.
Okay.
But then the owner may have to file a 7 or a 13 because that personal guarantee is on the owner. 13 if he has assets or has money to pay. If not, he files a 7 as well. Okay, so the next thing is, and again, this is really important too. If an LLC files for a Chapter 7, that's a bankruptcy of the LLC. A trustee is appointed. The trustee's job is to find money to pay creditors. But let's say the owner has been taking money from the LLC to pay for personal family expenses. Then what happens is the trustee could go after the owner for the money. That would suck. Because you're intermingling the accounts with the business and individual. And that's like an alter ego. I don't know if you guys have heard of that, but alter ego means they're one and the same. So that happens a lot too. Yes, sir.
Yeah, my question earlier was, LLC, the S corp.
Right.
S corp is a pass-through entity. So they said, if you have an S corp, it's still you, because you own it.
Well, you do if you make an election, yes.
That's it.
Tax purposes.
Profits.
Yeah.
But the question is, how do you shield your personal asset from profits?
You have to treat the LLC.
Or-
Well, if your asset is in a corporate or LLC entity, number one, right? And you are the managing member or the shareholder or CEO of that entity, if the entity files for bankruptcy, then you individually can protect your personal assets so long as you comply with the rules, meaning you don't pay for your house payment and your kid's school from the corporate bank account. You have bylaws, you have operating agreements. You have to show that you have to live with the distinction. That's number one. What I'm getting at is where that corporation took a loan, but the personal individual guaranteed it. So the corporation bankrupts itself, but the lender still has a guarantee against the individual. So that's where they can collect. But yeah, so there's two different distinctions. But yes, I mean, in order to have that distinction of corporation, you gotta comply with the rules. I mean, if I'm an attorney, if I'm gonna sue somebody, I'm gonna sue the corporation, the individual's wife, their kids, take their blood. I'm gonna do everything. But you have to prove that there's no, what is called alter ego, that the entity and the individual are not one and the same. They're actually acting like differences, you know?
See, you cannot get a property, get an LLC without a personal guarantee.
You cannot get a loan on the property without a guarantee. No one's gonna give, I mean, maybe somebody will, but they want their security, so they're gonna do that. And the LLC will have no credit at that point, right? If you're a developer, you're gonna buy property with a loan, they're gonna take a PG, and then you're gonna put title in LLC, right? Does that make sense?
So comply with rules for distinction of corporation.
Corporate shield, yeah.
No,
Yeah. What's that? Don't commingle. Oh my God. I mean, we could do a talk on Ponzi schemes and corporate protection if you like, but as you saw, in 52 minutes, I went over one topic. I'm so sorry. And I lost my iPad stuff. No, go ahead.
The benefit of 13 is, and then the benefit of 7 is, like, really quick, you said like 3 titles for each.
The benefit of a 13, I will say, is it'll buy you the time to sell property. It'll allow you to strip off a lien. Now, for example, this was the other important thing. Let's say the property is worth $1.6 million. Yeah. And yeah. And then the first mortgage is 1.6. Now, what if you have a second of 200,000? That's worthless, right? So you could file a motion with the court and say, Your Honor, this should be removed. But it's not really removed. What you guys have to understand is it's taken out and put into the pool of unsecured debt. It's treated like a credit card. So if the credit cards get 2% on the dollar, they would get 2% on the dollar. However, the next most important thing is that is not removed from title or your property until you finished all your payments in 3 or 5 years. Then only do you go to the court and get that order. So that's, I mean, I don't see this happening much these days because the properties are stupidly expensive. But when the recession happens in the next few months, 6 months, I think then you might see a little bit more of it. Was that?
But they've been anticipating that recession for a long time.
You know, they've been anticipating it for a long time, but I'll tell you what, I thought it was BS until recently, only because I'm starting to get bankruptcy, because I'm like 80% a business litigator. We do business litigation, but only recently has bankruptcy started picking up. And
All the SBA all that.
and what is the SBA loans? Personal guarantees, right? All the loan modifications people are happy about, can't do it. The job market looks good, but is it really realistic, the records they're giving you? I don't know. But I mean, my point is I'm seeing more bankruptcies now than I did before. So that's, and I don't know. I mean, recession is not good, but it hasn't happened in what, 10 years, it seems like. So it's like, it's something's got to give. But anyways, only because I see more bankruptcies, that's why I bring it up. But I see more bankruptcies in small businesses. And now I'm seeing 13s because of the fact that people are getting ready to lose their home, you know? But I still think bankruptcy is maybe like, in your knowledge base of law for potential clients, I still think bankruptcy maybe like 10 to 15%. You got to know about the trust. You got to know about the will and probate. That's where the future is heading on real estate transactions.
As far as for showing income on chapter 13, so they can make payments, obviously W-2s out, but if they're self-employed, their business is in direction. Can they use rent? for loans?
Yeah, you can do anything. You could have family contribution. You just need affidavits and declarations that are going to support what's going to happen.
Who is it?
Yeah.
I'm in meeting.
Are we good? Are we done? Okay, do I have to terminate? It's 11 o'clock. Oh, no. There's no charge. Well, I mean, you can ask me anything. I mean, if I know it, I'll answer it.
real estate professional. So our aim would be to list their property.
Well, your aim is always list their property because you want commission.
Have this equity position, this current public status. Why aren't you selling your home? What? Why aren't you putting your house on the market?
You could say that to them, and that's the max you would say.
They say they can foreclose. I'll be in this house until the sheriff comes, because the sheriff never comes.
Yeah, that happens a lot. You want to, well, you know, as a real estate professional, again, you can't give advice, but what I would say if I was in your position, I'll say, look, I don't know much about the legal stuff. I mean, I've seen online, I've read online, but I would suggest you meet with an attorney just because I don't know what your liabilities and risks are. So before we enter into this listing agreement, why don't you figure out your answers and let me know? Because again, I mean, if the sheriff comes, the sheriff's going to come. There's going to be a UD. They're not going to leave. There's going to be a UD lawsuit trial, which they're not going to have money for. They'll be kicked out by the new owner. And then what? It's like, I mean,
This has been going on for years.
I've seen those exceptions. Yeah, no, I've seen that. I mean, I was the attorney in a few of them. I know. I know what you mean. Yes. Right. So the advantage of the 13 was, number one, was giving your seller the time and ability to sell the property for top dollar. The second advantage would be to take away that lien that has no value to it. The third advantage is they can voluntarily dismiss the case. If they don't want to do it anymore, they can dismiss it. Maybe it just buys them a little bit of time for something to happen, you know? So that's the benefit of the 13. 7 is, when it comes to real estate, well, yeah, it's not really, 7 was more benefit for the real estate professionals in this topic than the actual individual. The real estate professionals, if they're suffering from a lot of debt, they haven't had that transaction happen, it might be a good way for them to kind of get rid of their debt and start over. It's a starting over point. That's what chapter 7 is. Yeah.
In chapter 7, regulation was changed. About 10 years ago.
So 2005, I think.
Yeah. Before that, doesn't matter if you're a wealthy guy, you can file chapter 7 and protect everything you own.
Well, they came up with the means test, which basically is a test where they calculate the asset versus liability and disposable income. That's the current one, yeah. Yeah, oh yeah, I mean, back then there was a lot of bankruptcy fraud. That's why they incorporated all these rules in 2005, I don't know, like a long time ago, but now the rules are, it's a mathematical equation, assets versus liabilities and how much money you have left after your qualified expenses. It's like, you know what it is? Who's done underwriting before? Anybody? Okay, it's like underwriting. That's what it is. A bankruptcy is like underwriting. You have the trustee who's the underwriter, and that's all it is. Does it make sense? Yes.
But I've seen some stories about trustees being horrible. This trustee that handles those cases.
Oh yeah, some of them are horrible. I mean, I've sued them. Some of them are crazy. I shouldn't say crazy. I mean, I work with a lot of them, but I mean, they're just like, they don't make any sense, or they don't. That's right. They are, I think, appointed. I think they apply and they get appointed. I mean, there's trustees in chapter 7, there's trustees in chapter 13, there's the United States trustee. There could be fiduciary trustee that are just appointed privately, just depends. No, the exemptions are the same. It just depends. No, they're the same in both chapters. It just depends how you apply them and the state and the amount and your strategy. Yeah, yeah.
And I also see this case with the loan modifications, right? Where the first position was modified, the second position was completely wiped out.
Yeah.
Title was released, but some, they send you a 1099, and then that means they convert it to consumer debt.
Yeah.
And then the title is still there. And then they never collect money after they started the limitation. Especially in California, you cannot collect.
Yeah.
You cannot sue. They're gonna tell you that on the letter.
Yeah.
But that lien remains in the title.
Well, that's like credit cards. That's like a credit card judgment. If you have a credit card judgment, and if your attorney, if you file chapter 7 and your attorney doesn't avoid that judgment off the property, then you go to sell the property, that judgment's going to show up. and you have to go back to the bankruptcy, reopen it, or make a settlement. So that makes it complicated. And then not to mention the debt forgiveness issue, right? How does that taxes deal with that? So that's why I say bring a CPA in, because the amount of money in this valley, I think it's really important you have a team with an escrow and a CPA and the attorney, because you might get hit somewhere else, or you might get hit on taxes. There's always different issues that come up. So, and that's with any business. Have a good team around you. Make sure make sure you talk to escrow beforehand to say, look, I'd like to connect you with the attorney to make sure the bankruptcy order with the court is clear. Because just because the judge signs it doesn't mean escrow is going to approve it. And that could delay things even further. So you have to be the proactive one.
You said you're in San Jose still?
I'm in San Jose, yeah.
Can I share a scenario that I have, or should I just save it?
Up to you.
Okay, so I have a client, house is listed for 1.6. They were in chapter 7. They got dismissed. The trustee said there's no money there. The reason why they say that is because their first loan is for 560,000. Their second loan is for 9, so that's 600,000. But the property's worth about 1.6. There's $1 million there. What happened is that they have a lot of liens, IRS liens, state liens from the business falling apart during COVID.
Right.
I also do taxes, so through my investigation of their liens, I discovered that a lot of those tax returns weren't filed, so they are allowed to file tax returns and get those liens removed. But it takes a long time.
Right.
And as a matter of fact, I removed already about 200,000 of it just the other day, but I'm running out of time because the foreclosure is August 19th.
Yeah.
They did call another attorney. They didn't want to take the chapter 13 because they had just got out of chapter 7.
They didn't want to take the 13 because
They didn't
individual.
want to file chapter 13 'cause they felt like all you're doing is that game. You're gonna file chapter 13, you're gonna delay while you clean up these liens, but that be in their best interest. There's a lot of money there for them.
Well, you don't have, the problem with the 13 is you won't have unlimited time to clean up the liens, because the judge is going to be like, what's going on, what's going on, what's going on?
Right.
At the same time, what option do you have? File it. See, the thing is, well, the question was, is 7 dismissed or discharged?
This, because the trustee saw that there's over $1 million in liens, but it's completely wrong. I already got rid of like half of it. I'm running out of time.
But why would they dismiss it if they?
They dismissed it because they also didn't make they were originally in chapter 13, they didn't make their payments.
So it converted to a 7.
They converted to a 7. And the family is just under a lot of stress. Everybody's sick. They're very old elderly couple, and the sons are trying to help the parents out. So the communication process broke down between them and the attorney. So the attorney just got frustrated with them, and the trustee, they dismissed the case.
I'll have to see the doc. Give me the case number. I'll have to dock it, check it out what happened. But yeah, I would, from first blush, I think you could file at 13, but the question is, what's it going to get you?
Well, at the fastest, 3 months to get rid of the liens. Most likely in 6 months, a good portion of there'll be money left over. I know for a fact. It's just sad to see them lose the house when they only owe 600 to the banks. These liens are long.
Well, they got to make payments. If they can't if they can make their payments in the 13, that might give you the time. But if they can't make their payments in the 13, that's the option. That's the option. You need payments. You need money in the 13. Something.
But the sons can participate.
Absolutely, they can do family contribution, confirm a plan, make the payments, and work on your liens in the background. If they'll work with you.
It'll-
Yeah.
They will end up with money instead of having to put those.
Yeah, it depends. It depends on the details. Yeah. I'm in San Jose. I'm moving from downtown to the Alameda. So no, not tonight. I wish. No, probably next week. Yeah, the Alameda here.
Well, the Alameda here.
Yeah, the Alameda here. Yeah, I'm not moving out. No, I'm not moving to Alameda. No way. No.
The bumps are everywhere, but they're not over there. You meant
Well,
particularly
they're-
downtown. You're in
they're-
downtown.
I'm in downtown. Yeah. So like 5 minutes away.
Bumps in that too.
We got a lot of bumps there too. Yeah, absolutely. Yes.
Yeah, okay, so we have this listing, right? And then the market value is 2.5,
Okay.
and then they owe 1.5
Okay.
to the lender. So now I probably need to reach out to the attorney with the authorization and understand that it's not subject to the court approval, right?
Well, if there's a bankruptcy and you have a listing, in order to complete the transaction, more likely than not, you're going to need court approval. But it's going to depend on the chapter. Okay. It's 13. You probably need a court approval unless your attorney did something else. You're going to need an approval. So to be proactive, what I would do is talk to the attorney.
And so I don't know, this is a valid question too, but do you think they can use that the Prop 19, like you have to pay too much taxes on the property? Is there any?
That I don't know. You'll have to. I haven't heard of anything with the bankruptcy relation, but talk to the attorney because he may have somebody he's working with regarding Prop 19. Yeah. And also, what are the capital gains like? I mean, that's what you want to check on too.
It's gonna
Right.
be high.
Yeah. So make sure they know all that. Well, you're not supposed to advise them. They'll get somebody, but yeah.
In your law firm, are you by yourself or with other attorneys?
I have an associate, a paralegal, and an admin. So 4.
You don't have in your team a tax attorney.
I refer to a tax attorney. Yes, I have referrals.
This guy's very good, I'm telling you. It would be nice if you do it again in the future, if you have like case scenarios that we can go back to.
Well, I did. I have a bunch of them where I drew pictures and everything. See, it's all the pictures, the houses, the liens, everything on there. What's that? No, these are just, I like to draw, so I draw the pictures and I do all them, because we talk about dead people, DA, I found property in the backyard, it makes it fun, but I do case scenarios actually, my seminar revolves around 4 case scenarios, which are pretty detailed, but today I don't know what the hell happened, it just kept going. Yeah, and every single one of them, I mean, I have a case, and I'll tell you, it was one of my first cases. This lady showed up to my office and she was, I thought she was gonna stab me. She was really scary. She came to my office and she said, my mom passed away and the house is in foreclosure. I'm like, well, okay, what do you want me to do? She's like, I want you to stop the foreclosure. I can't stop the foreclosure. There's no probate, there's no trust, it's not even in your name. So I filed the bankruptcy anyways, because I was young and risky. And back then there was a judge who actually was more for the debtors than the creditors. So minutes later, the bank calls me and yells at me and says, you know what you're doing, blah, 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 blah. I'm like, yeah, you're right. I played stupid, right? But the judge gave me 6 months. He's like, let's finish the probate and get everything going. So then I got a probate attorney. She got the property titled to my client. Then my client sold it and got about $600,000. Then she disappeared, right? I didn't get paid. She took off. But then we find out that the DA's dogs have been sniffing in the backyard because the deceased killed her boyfriend, buried him in the backyard. And then while driving, so the guy died in the backyard while driving, she beat up her husband in the car. So then the question was value, right? We couldn't figure out value. Is a dead person in the car or the dead person in the backyard? Well, what affects value more, right? So that was it was very interesting, right? Because but that was my first case. But the interesting component from there is you had a probate pending with a bankruptcy. So how many orders do you need? You need 2 orders. So if the probate order satisfied escrow and the bankruptcy order doesn't satisfy escrow, it's a nightmare. So luckily, the real estate agent in the probate section knew what they were doing. So we were able to get those orders done by escrow, approved by the court, and sold. So it was such a learning experience because it's like, if escrow is not happy, this is not happening. And if this is not happening, the case is not closing and commission is not happening. So it was such a learning experience. And it was an interesting case. I mean, dogs in the backyard sniffing for the bodies.
Sometimes, like you said, you have to work with a court attorney, a tax attorney.
Yeah.
Maybe the property attorney. Plus, sometimes it depends who's the judge's son.
That, these days is more true than ever. Like when yeah. It depends. In bankruptcy court, it really depends. I think more than even state court litigation. Bankruptcy court, some guys are just pro creditors. Some are just pro debt. I mean, I was in I think court a couple of months ago and I'm sitting there and the US Marshal walked in. We had the FBI, US Marshal, and I was representing an individual in a bankruptcy. And this judge had given me so much time before she called the marshal. I couldn't believe it. I was like, really? Okay. And the other judge would have got me right then and there, so it just depends on their mood or whatever they are. But yeah. So to answer your question, yes, I have all the scenarios you need. I have color drawings, color coded and everything. But you guys just shot out questions today. That was awesome. You guys just knew everything already.